Good morning, everybody, and welcome to Irish Teacher Institute's information session on rights and contracts, what you need to know, as part of ITI's Accelerate programme. ITI's Accelerate programme comprises of information sessions, workshops, masterclasses, mentoring and training, and it's aimed at addressing issues encountered by the independent theatre artists and workers. This training and this information session today is possible due to Rethink Ireland's Innovate Together Fund. This is our third information session in the series, and this morning's session will be led by Andrea Martin, media lawyer. For over 20 years, Andrea Martin has been one of Ireland's leading media and entertainment lawyers. We're also delighted to say that she served on ITI's board for 6 years, and her knowledge has been invaluable to us. So thank you so much, Andrea, for joining us this morning. And I'll hand over to you now.
Thanks, Lee, and good morning, everybody. And it's a pleasure to be with you. We're in a very interesting time of change in terms of theatre and how it's presented. And that is posing a lot of challenges that haven't been worked out as yet. But I think as an industry, we're all beginning to work through them, and I'd be presumptuous enough to include myself in that, as I'm receiving a lot of questions about how do we structure our contracts in an era. Hello? When increasingly work is being produced and used and reused online. So let's work through. I have a presentation here, as I say. Pop your questions in a chat room. I'm not technically brilliant, so if Lee will be monitoring the questions in the chat room, and if I don't pick them up, Lee, you can raise them with me, and then feel free to interrupt me with the questions, and I'll either say, hold that question because we're going to get to it, or else if it would be helpful to expand on that question at that particular point in time, because often questions stimulate that, we can deal with it at the time. Now, dear slide, please press on. There we go. What I'd like to do in the next 90 minutes is to convey an understanding of baseline intellectual property, IP rights, inherent in theatrical productions, to talk about the assignment of rights or granting of licenses, permissions to use those rights in a contract situation. Something that comes up increasingly, and I'd like to look at it with you, is retaining personnel for theatrical productions. Do you retain them as, or do you ask to be, or expect to be retained as an employee or a self-employed contractor, and what the implications of those two different types of contract are? Legal issues raised by creative collaborations. When you're there in a, what do you call it, a collaboration room at the start, when you're all firing ideas around and trying to create work, and there's a few of you there, who actually owns that work at the end of the day? There's no clear answer to that, but I'd like to sort of guide you in how to look at it, how to possibly approach that situation. And as I said, legal issues raised by digital work. So basically, the first part of our session today is going to be a straight presentation, and the second part is more likely to be along the lines of a discussion based on that presentation. I may well have given you more information than you need here, so if I skip over some slides, it's because I know you can go back to them and look at them for at a later date for reference purposes, rather than focus on points that may not be absolutely directly on point here today. First of all, though, I'd like to go back, and I'd like to say here, there is no such thing I've learned over the years as a silly question or a stupid question. Most of us have absolutely baseline questions that we want to ask about a situation or an area of law, and yet everybody's there spoofing. I'm a great believer in putting my hand up and saying, hi, I don't understand that. And you'll find that loads of people around the table will say, thanks you up for asking that. I don't understand it either. So let's go back to Copyright 101, because I don't think we can emphasize this often enough. And I even need to go back from time to time just to remind myself about the basic principles. And one way of explaining this is, look on this as tangible versus intangible property. For example, I own an ironing board. I found that my ironing board is the best Zoom elevator that I have gets me the perfect angle. So actually, as I sit here, I'm sitting in front of my ironing board. My ironing board is a piece of tangible property. It's physical. It can be seen, not by you, thank heavens, but it can be seen, it can be touched. I can sell my ironing board on eBay. I can lend it to my next door neighbor. I can give it away to my sister. Or if you're really stuck for an ironing board, you might try and steal my ironing board. But that's what happens to tangible property. Then there's property that isn't so tangible. It's the property right that exists in the product of somebody's thoughts, imagine, ideas, enterprise. And that intangible property, it can't actually be touched as such, but there is a property right in it. And equally, it can be sold, it can be borrowed, it can be given away, or indeed it can be stolen. When somebody breaches somebody else's property right, it's equivalent to stealing their idea and using it for your own benefit. Now, I hesitate to use a word as strong as stealing because sometimes it might be inadvertent, but you need to be very careful not to inadvertently steal somebody else's copyright. We'll be looking at how that can be inadvertently done and how to manage that. What's important to understand. No, I'll talk about that in a sec, back to writing down or recording an idea before copyright exists in it. Copyright protection was first adopted internationally in something called the Berne Convention at the end of the 19th century. And all of us are nationals of a Berne Convention Union country because Ireland, among other 160 other countries over the years, has signed up to the Berne Convention. And if you are asked to sign a contract saying that you're a qualifying person for the purposes of copyright law, it just means that you're ordinarily resident in a Berne Convention country. And the Berne Convention ensures broadly similar copyright protection across a range of countries. We now have 160 countries signed up to the Berne Convention, and we have protection that goes across the EU as well, enhanced protection. But if you are a qualifying person, it just means that you're ordinarily resident in a Berne Convention country. We've got different types of intellectual property right. The four basic types that are protected by legislation are copyright, trademarks, patents, and designs. Copyright, trademarks, patents, and designs. They're all protected under law, and there's a lot of very useful information on the Intellectual Property Office of Ireland government website. I've given you a link there. I would, for any of you who are stage designers here today, the designs, the type of designing that you're doing is not the type of design that's usually protected by legislation. Design is, for example, the design of my mobile, my iPhone, how it looks, the line, the look. Or a bottle of Coke, how it's molded, how it looks. Those are the type of designs protected by copyright law, but we'll be looking at the kind of rights inherent in theatre and set designs and other types of design shortly. Now, what is the right? There's no need to, all those other types of copyright, of intellectual property, trademarks, patents, and designs are protected on a register. But there's no copyright register. Copyright automatically exists in a written or recorded expression of an original idea. And that copyright automatically arises and vests in the person who came up with that original idea. So a copyright holder has a right to copy the work, threefold: copy the work, make it available to the public, and adapt it. And a breach of copyright is doing any of those things without the permission of the copyright holder. There are certain exemptions, but we look at those later. So, as the creator of a copyright who originally records or writes down or in some way fixes in a photograph or a picture or a drawing, the original idea is the original, under copyright terms, original author. Author, not in the literary sense, but the original author in the sense of the original creator. So when you come up with an original idea and you express it in some way, written, recorded, photographed, then you are the original copyright holder. You and only you are the person who's entitled to copy it, make it available to the public, and to adapt it. However, you can, if in effect, sell on that right in different ways, and we'll be looking in more detail at that. Copying includes something you might hear about, the reproduction right, but that's an expanded version of the copying right. The making available right, which is set out in copyright law, is an expansion of the right to make it available to the public. And the distribution right is a form of an element of copyright as well, which includes the right to make copies of it and distribute those to the public. Rental and lending right is also an aspect of copyright, but it's another way of making it available to the public. There's a right to rent it and lend it. There are some exceptions where if they're available through a public library, you can collect certain fees through a rental and lending rights scheme. But all of the above acts require the copyright holder's consent. So to copy, to make it available to the public, and to adapt it. And that includes reproducing it, making it available, distributing it, renting it, and lending it. It's what's called a property right. It automatically, as I've said, subsists in the written or recorded expression of an original idea. Now, it needs to be an original idea. It may be inspired by something you've seen. Obviously, ideas build on ideas. But when you have something that is unique and original to you, that's when you can claim copyright in it. It may be assigned, licensed, or sold. And we're going to look at the difference between an assignment and a license. It can also be inherited because copyright lasts after the death of the creator, which is why, for example, Samuel Beckett's works are, now they were in copyright until very, very recently, which is why because Samuel Beckett never agreed with the idea of A Waiting for Godot by women. He wanted a male cast in that. He said he wrote it for a male cast. But recently, the Abbey, because Samuel Beckett's work went out of copyright, was able to put on an all-woman version, which would have Samuel Beckett turning in his grave, but there we are. Unfortunately, I missed it because I was dying to see it, so I hope it's available somewhere. And that's interesting. Will I have to pay? Where is it available? We'll look at that in terms of digital platforms. Any unauthorized use of the copyright is unlawful, subject to certain exemptions. And there is no copyright registry in Ireland or anywhere in England or the US, or the EU. There is a copyright registry in the US, but you don't have to register your copyright in order for copyright to exist. But you do have to register your copyright if you want to litigate to protect your copyright or stop somebody else using it. Who's the first owner? The copyright subsists automatically in original, literary, dramatic, artistic, and musical works. A dramatic works includes a choreographic work or work of mime. The person who creates it is the first owner. And there's also a concept of joint authorship. If a group of people in a room collaborate together on creating a work, and you can't tell who created which bits, each bit of work, you can't say, oh, that was created by Lee, and that was created by Catherine, and that was created by Andrea. If they're all mixed in together so that it's genuinely a work of joint authorship, then the joint authors operate as one, unless there is some agreement whereby you go into a room and you say, right, we're going to work on this piece today. And everybody signs something saying that, look, the copyright will belong automatically to the director or the writer, subject to, for example, those of us who collaborated in it getting first dibs to play the roles we created or something like that. It can depend very much on what you agree in the room. But a lot of the time, it's not set in stone what happens. And if somebody's being paid to collaborate on the creation of the work, that's different if people are getting together in a room and they're saying, right, let's all work together on this. And if we can get money to put it on, then we'll all get a share of that money, or we'll all get a role in some way. It really depends very much on the circumstances. And it's terrible. You don't want to, it's very difficult to find the balance between a creative buzz with everybody working together, and putting legal parameters on that actually restrict the creative buzz and crush that lovely creative vibe before it even starts. It's really difficult to get that balance. But those are the kind of issues you need to think about and be aware that there is such a concept as joint authorship. I've said already that literary, dramatic, music or artistic work, including photograph, the duration of copyright is 70 years after the death of the author. So my granddad wrote interesting but somewhat obscure books about ancient Irish poetry. And my mother, who's still alive, but she's 88, would still get, he died 63 years ago. So for another 7 years, his work is in copyright. So if anybody wants to republish his work, my mother gets a small royalty on it because his copyright still exists. But in another 7 years' time, anyone who wants to publish early Irish lyrics by Garrod and Murchú would be entitled to publish it without breaching copyright. And so it is with the work that any of you create. You're probably providing for your grandchildren in some small way, but you don't realize it, but you actually are. Now, let's look at the rights, because this is something that people can get a little bit mixed up about. There's a copyright in the written recorded expression, but actors and performers, musicians, people who are reciting, people who are acting on stage, they also have very similar rights in their performance. If it's a qualifying performance, it means it comes within this statutory definition, which is set out in the Copyright Act 2000, Copyright and Related Rights Act. A performance, for the purposes of this act, means a performance of any actors, singers, musicians, dancers, or other persons who act, sing, deliver, declaim, play in, interpret, or otherwise perform literary, dramatic, musical, or artistic works, or works of folklore, which is a live performance given by one or more individuals and includes a performance of a variety act or similar presentation. So a live performance given by one or more actors is a qualifying performance, and those actors have certain, and musicians have certain performers' rights that need to be addressed, as well as copyright. So what are the performers' rights? A performer, it boils down to this: they have the right to authorize or prohibit, so their consent is required, to making a recording of the whole or a substantive part of their qualifying performance, to agreeing to the live broadcast of the whole or substantive part of their performance, or to make a recording of a whole or substantial part from a live broadcast. Don't worry about that too much. But what it boils down to is that if a recording is to be made of your live performance, then you as a performer have the right to, you must give consent to the making of that recording and the use of that recording afterwards, if it's going to be online, on TV, or wherever. So you need to be, your consent is required. Those are where your performers' rights exist. Similarly to copyright, there exists for performers a reproduction right, which is making a copy of the recording, making available right, making the recording available to the public, distribution right, your consent is required to distribute copies of it, for instance, in DVD format, and a rental and lending right if it's going to be rented out. You know, when you download from iTunes, you download, do you want to rent or do you want to purchase this film? And it's cheaper to rent it, so you get access to it for 48 hours, I think, from the time you start playing it, and it remains available on your device for 30 days. That's a rental. But if you buy it, you actually purchase it, download, and you keep it forever on your laptop, for so long as your laptop is still running, it's in your iTunes library, then you've actually purchased it. It's a distribution right to making available right. So performers have the right they must give consent to the making of a recording, and then anything else that's done with that recording also needs the consent of performers. That's for musicians' right to equitable remuneration for the commercial exploitation of a sound recording. It's also important to note that performers, as well as copyright holders, hold moral rights in their work. So let's look at moral rights. Moral rights are twofold rights that are automatically, by virtue of legislation, inherent or held by the original creator of a copyright work and the original performer in a performance. And they are what I call the paternity right, which is quite sort of gender-based in its expression, but I call it the credit right. It's the right to be credited as the original creator of that piece of work, the original performer of that performance. And the integrity right, which I call the edit right. The integrity right is, in effect, the right to object to any distortion, mutilation, or other modification or derogatory action in relation to a work which would prejudice an author's reputation. So, for example, if you really, in theory, you could object to the way in which a recording was edited. No, that is no way how I meant my performance to be presented. What will usually happen is that a producer, and if I was wearing my hat as the advisor to producers, I would always say, get a performer or a copyright holder to waive their moral rights, because you do not want to be having a row as the producer about an edit of a performance. Or get them, and in turn also say, look, by this contract, I'm giving you a right to be credited as the author. You're not getting a right under copyright law, but you're getting a right to get a credit under this contract. It's a little bit of a head wrecker, but if you waive your moral rights, you make sure that you get a right to a credit under the contract. So you have a contractual right, even if you don't have a statutory right because you've waived it. If there's a difficulty about it, I would always say I waive my moral rights to the extent required for a bona fide edit for time and other reasonable purposes. So that, somebody who's creating a very serious work doesn't get portrayed in a ridiculous, humorous way. Though, you see, these are the kind of discussions that you just don't want to get into. But a bona fide edit, a bona fide good faith presentation of the piece of work, I think it's reasonable to settle for that. Performers also hold moral rights in their performance, exactly the same moral rights. Similarly, a waiver or a sufficient waiver that you can make a bona fide edit of it is required. So if you are putting on a production, you have several layers of underlying rights in the piece of work that you eventually make available to the public or produce for the public. I look on it as a piece of cake. That the piece of cake is the cake is the final work, and it's one item. It's a cake. It's your theatre work, and I don't mean to be derogatory about theatre work in any way, but it's just an image that I use to create it. And if you imagine that the cake has loads of delicious layers, and each layer is a layer of IP rights that need to be cleared. Are you using any audiovisual montage? There's the rights of the right. Then who created that audiovisual material? Who's the copyright holder? Are there any performers in it? Have all of those rights been cleared sufficiently to enable me to integrate it into my theatrical piece? Are there the script or the text that's being used? Has that been cleared? Am I using literary quotes? Has the scriptwriter, has it all been cleared? If it was a collaboration in a workshopping situation, has everybody given consent who might have a right to claim part of the copyright? Photographs, film, other graphics, the music that we're going to need, and obviously the performer's rights as well. So you need to think in terms of, am I clearing all those layers of the cake so that I can present the cake to the public? And in what way am I going to present it to the public? Now, I talked earlier about you can either assign or license. And this is important, particularly when it comes to retaining people to work on your theatre production, or if you are somebody who is being retained by a production company to work on a theatre production. You can either assign your copyright or your you can't actually assign performers' rights. You must actually give consent there. Or you license and give permission to use that copyright or performer's right. So here I'm going to, you're going to need to bear with me because I'm going to try a little bit of alternative screen sharing. And I hope to goodness I'm going to be able to get back to what I want to do now. Is there some music and a graphic appearing on your screens there, Lee?
Just the music at the moment, not the graphic itself.
It's coming up. As long as you've got the music.
Yeah.
Have a look at this just 2-minute piece.
Explain the chair thing. Here I have a chair. I own the chair. I have a proprietary interest in the chair.
Sorry there, Andrea. I'm sorry there, Andrea. And the video isn't coming up there.
Oh no! Oh no! Damn. Well, do you know what? I'm just going to act out the chair thing for you. So, somebody made an animation of it for me a couple of years ago. Okay, a little bit like my ironing board. Let's assume I have, no, I'm going to use my ironing board. There we go. I have an ironing board, okay? I own the ironing board. I have a proprietary interest in the ironing board. You come along and you see my ironing board and you say, oh, haven't had an ironing board for months, haven't needed to iron anything, but I got an audition next week and I want to iron my blouse. Can I buy your ironing board? And I say, actually, yeah, I'm going to get a new ironing board. Take this one away. And if you give me a $5, you can have that ironing board forever and ever. You can iron your clothes in the street. You can iron it in your apartment. You can iron it in your mother's house. But the ironing board is yours to do what you like with. So what you do is, I see a question coming in there, and I'll come back to that one because we're coming to it. So I've got the ironing board. You buy the ironing board from me. I have assigned my proprietary interest in my ironing board to you. I no longer own the ironing board. That's an assignment of my proprietary interest in the ironing board to you. Bye-bye ironing board. Now, scenario number 2 is you call in, we're having a cup of tea, and you say, oh, you've got an ironing board. Listen, I've got to iron all the football jerseys for my daughter's camogie team. Could I, or camogie jerseys for my daughter's camogie team, could I have the ironing board for a week? And I say, okay, I am going to license the right to use my ironing board to you. You can have the ironing board on condition that you take it, you only use it in your house, you only use it for ironing your daughter's camogie team's sweaters, and you pay me €3. What I have done, and that you bring it back at the end of the day, what I've done is I have licensed my proprietary interest in the ironing board to you. I still own the ironing board, but I have given you permission to use it on certain agreed terms. You're going to give me €3. You're going to use it in your house. You're going to use it for ironing your daughter's camogie team's shirts and nothing else. And at the end of that license, you don't use it for anything else. You bring me back the ironing board, and that's my ironing board again. I can lend it out to somebody else or whatever. That's the essential difference between an assignment and a license. And it's exactly the same with your work. When you create work, you either, it's a buyout situation and they sell the creative elements, the IP elements in your work, you assign it over to whoever pays you, or you agree terms on which you license it. Performers agree terms on which their consent is given to the recording and use of the recording of their live performance. So that's the difference between an assignment and a license. Now I'm going to go back, I sincerely hope, to screen sharing. Okay, we screen sharing again? Good. Now, here we go. And I hope this goes on to, I saw a question coming up from Mairead there, and I hope this goes on to to addressing that question about signing off on contracts. I'm not taking calls. I'm just setting my timer for another 30 minutes. I've divided this into 3:30s so that I don't keep you all here all day. So if you when you are signing up to do a piece of work for a theatre production, you're contracting for the use of your copyright or your performer's rights by someone else. And you need to think in terms of who owns the rights? Am I selling, assigning them, or licensing them? And how are we going to manage the question of the ownership and the use of the intellectual property rights in my work? So you need to be clear about the extensive rights that you're granting or licensing. A grant, license, permission is all the same to or by a third party. It should be in writing. An assignment absolutely must be in writing. A license can be implied. So are you going to grant those rights for one show, an entire production run? Are you going to, these days it's probably going to be more likely, is it going to be a live recording with a live stream? Or is it going to be made available online later? Are the fees going to be paid up front, or am I going to get an upfront fee plus a residual if it gets used again, or residual, or a royalty? Or are there going to be any other further fees? For example, if I'm a sound designer or a lighting designer, am I going to get further fees if that same lighting design is used for a further show? The interesting question is, if there's going to be further live stream, am I going to get because time was, if a show was toured, you might take the same lighting design and say, right, we'll use that. And effectively, it's a software program, these days. And you'd use it in another venue and there'd be another payment made to the lighting designer. But if we're these days looking at, well, we're going to make it available we're going to give it to various regional theatre platforms so that they can make it available to their audiences, or we're going to move it on to Broadway Theatre's platform, and they're going to promo it, then we're in a whole new territory. How do you work out what residuals and royalties are going to be payable? I'll come up with a suggestion for how it could be approached, but it's absolutely new territory at the moment. What media and formats is it going to be used in? If a recording is made, can a DVD be put out of it? Can it be made available on iTunes or Amazon for download? Can it be translated? Is it going to be shown in Ireland only? Is it going to be geo-blocked to Irish audiences? Is it going to be made available overseas? Is it exclusive or non-exclusive? Can I sell the same? Now, usually if you design a show, that you're not going to be able to, that it's going to be show specific. It's going to be exclusively to that show. But these are all the ways both parties need to be thinking. Something I'd like to point out to you, because I'm going to come on to employee versus self-employed contractors contracts, that copyright law states that an employer owns the copyright in an employee's work. So PAYE, PRSI employee, the employer owns their copyright unless it's otherwise agreed, but that's very, very rare. But a commissioned piece of work and a self-employed, and that stage design, costume design is like a commissioned piece of work, because you're asking, so you're going to pay somebody money to come up with a piece of work, and particularly if it's a commissioned a script, something like that. The copyright automatically, even if you as the producer are paying for it, the copyright doesn't become yours unless or until the copyright holder signs an assignment of their copyright in writing. An assignment must be in writing, or else comes to an agreement with you. And this is more common, that the ownership of the copyright stays with the original creator, the scriptwriter, the lighting designer, stage designer, or the entire show designer. The copyright stays with them, but they agree the financial terms on which they'll allow you to use that work, i.e. you agree license terms. There's a journalist, there is an exemption for journalists, but you can look at it later if you're interested. And if you also see, just beware, if you ever see the term works for hire in a contract, it means there's an American angle or somebody's borrowing it from an American precedent. US law is different. If you pay for it, you own it. If you're the producer and you pay for it, you own it as a work for hire under US legislation. That is not the case in Europe, England, or Ireland. A work that is commissioned, there must be an assignment in writing for the commissioner to own it. People often forget that, and they say, but photographs even, but I commissioned them, I paid for them to be taken and to be made. Why don't I own them? You don't own them. You need to have an arrangement with the copyright owner as to the extent to which you can use them and the commercial terms on which you can use them. Now, that all sets us up for looking at the contracting process. Contracts in theatre making. There are two types of contract for retaining an individual's services on a show. One is an employee contract. Now, this means effectively they're put on payroll. It's PYE, PRSI, there are fixed hours, more or less. I mean, I know theatre work, no less than film and TV work, involves some pretty crazy hours. Usually it's a fixed duration, i.e. a fixed term contract. There are very few organisations in Ireland or production companies that can afford to retain permanent employees. Usually your equipment is supplied, though increasingly people, it's called BYOD, bring your own device. Usually we all use our own laptops and phones because we prefer that, but any expenses, phone bills, etc., are reimbursed. Usually, only that individual can do the work. I can't send my sister in to do the work tomorrow because you want me. You want me as the actor. You want me as your stage. What's the word I'm looking for? Not stagehand, stage manager. It's to that individual. Also, the Working Time Act legislation applies. You've got to be given breaks, and 8% holiday pay must be given. This is why a lot of employers don't like using employee contracts, because they've got to make, if it's a short-term contract and no holidays are given, you've got to give somebody another payment at the end of the contract, and it's got to be separate. It cannot be bound up into their overall fee and say, well, your fee includes your holiday pay. Revenue have said that's not on. You've got to actually give them another check that's 8% of what you already paid them in lieu of holidays. So it's effectively holiday pay. That's an employee contract. In legal terms, but don't let this fry your brains, it's called a contract of service. I own you, you are my employee, okay? And a fixed term contract can be part-time or it can be full-time. A self-employed contractor is the other model. Now, this is somebody, you pay them a fee, a fixed fee, and they pay their own tax. They often provide their own equipment. They can do the job broadly in their own time, though the exigencies of making a piece of theatre usually involve that everybody's there at the same time. Technically speaking, they can substitute someone else to do the job, or they may be recognised as a self-employed Schedule D taxpayer. Okay, you probably heard Schedule D means revenue say, okay, we're happy this person accounts for their own tax. And they don't get holiday pay. They just come in, do the job, and go away again. And that is called a contract for services. I prefer, even I, after 30-something years in the law, rather than I have to think about every time it's a contract, I'll have a contract for, I just think of employee and self-employed contractor. And that's the way I find it easiest, but people have different ways of remembering it. Sometimes self-employed contractors will make their services available through a limited liability company. Often directors will do this. Basically, people who are doing quite well financially often do this because it just helps them manage their taxes more efficiently. They draw a certain salary out of their own company, which they own, but the company is technically speaking a different legal person from them. So you contract with the company, which is called a loan out company. And the company said, I am going to lend you out this, I'm going to make the services of this particular director, sound designer available to you, the production company. I'll look after paying that individual. Well, sorry, the company will look after paying the individual. You just have to pay the company. And you might think it's absolutely weird because the same person is signing the contract for the company as well as individually. But they're actually two separate people. Imagine there are two separate hats. I should have actually little hats for this. Okay, I've got my pointy hat is my company hat, and my beret, my little roundy hat, is my individual hat. But I'm actually wearing both those hats when I contract with you. So it's not too much of a head wreck if you imagine them having a pointy hat and a roundy beret. And you need to think I'm contracting with the pointy hat company to provide the services of the roundy hat individual. That's what a loan out company is about. My God, I hope that makes sense. It doesn't sound completely bonkers. So we're looking at an employee contract or a self-employed contractor. Usually, producers do not want the hassle of having to run a payroll, and they don't want to have the expense of paying 8% holiday pay and having grievance procedures and anti-bullying and dignity at work procedures and all the things an employer is supposed to do. And they much prefer saying, hey, look, I'll just pay you and pay you a flat fee and you look after your own taxes. It'd be lovely if you could do that, but it's not that easy because revenue, once they turn their sights on different industries. They turned their sights on film and television about 5 or 6 years ago and really clamped down on the use/abuse of self-employed contracts. And most people are on short-term fixed-term employee contracts now. Cast and crew are usually on fixed-term employee contracts for the duration of the production and the performances. So pre-production and the performances. So cast and crew are usually on short-term, fixed-term employee contracts, payroll in the works. Directors, sound designers, lighting designers, they're usually self-employed contractors, either under their individual names or loan-out companies. But you need to be satisfied that either they're trading as a company or through a company, or that revenue agrees that they're self-employed contractors. There's another form of contract, which is when you, for instance, you stage building, transport, if you had a big show, lighting hire, sound equipment hire. Usually that's a contract with a specialist company that provides a package, including equipment and a team of workers. It's a contract for a price. Just make sure that if there's any element of design in the work they do, that they assign that design to you. But usually they're just going to be implementing somebody else's design. But sometimes people get mixed up between the self-employed individual contractors and the stage building transport companies. That is different. It's a different animal. I'm concerned principally with these cast and crew employee contracts and these self-employed individual contracts, which is directors, sound designers, etc. They will usually contract either in their own name or wearing their pointy hat company name and contracting through that company.
There was one question in that, Andrea, just about if you're the artistic director of the company, but you also maybe are the actor, the contract is still coming from you as artistic director to yourself as an actor.
If you are an individual, let's say you're the artistic director, it's only if you're as the artistic director that you're also going to be there. If you are employing an actor, you're going to be employing the actor as a producer, right? Now, if you are actually one and the same person and you're not trading through a company, you'll just pay yourself as an actor because you own the rights already. You have the performance rights. You can give yourself consent.
Yeah.
Okay. But if you use, as an artistic director, if you use a company to produce your productions, then the company must issue a contract to you wearing your roundy hat beret as an individual to contract you as an actor.
Yeah.
And you're going to draw a salary for the duration of the run, a PAYE salary from your own company. Now, yes, that's how it works.
Brilliant.
But if you're an individual producing the show and you're not producing through a company and you employ yourself, all the relevant rights vest in you already. So you don't have to worry. Just don't fall into dispute with yourself, because it'll be a head wreck. Makes sense.
Yes, I think that is.
Okay.
Was it Mairead? If not, I'll get her to come back and we can follow up question at the end if it is.
Very
That's
few
great.
people are on my screen, but Mairead and Tim are on my screen. I saw a nod from Mairead, so that's good.
Great.
We can explore it later if we need to.
Thanks, Andrea.
Now, why can you not just say, oh, for goodness sake? And I know, and I've heard this, that actors will often come to a company and say, look, just give me a self-employed contractor contract. I want to get paid gross and I look after my own tax. And the temptation is to say, oh, great, fantastic. I know, don't need to worry about running a payroll, don't need to worry about holiday pay. Fine, I'll just pay you a gross fee. Because there is a nasty snag. If one fine day after, and it can be up to 6 years after, revenue turns its spotlight on you and does an audit of your production company. And if that audit reveals that the individual actor, for example, should have been given an employee contract, the production company can be required to pay up to 6 years back tax, employer and employee, PAYE and PRSI, plus interest, plus penalties. And that's the company's liability, not the individual. The individual has skipped off and gone on to do something else. That is the thing you need to be really careful about, because it's absolutely fine at the time. Everybody is happy. But if 6 years later or 5 years later, the production company gets an audit and it's found out that they should have issued an employee contract because the nature of the relationship was an employee relationship, and revenue always lean in favor of an employee relationship, of construing an employee relationship. It's got tighter and tighter over the years. Then you could be caught. You're much better off budgeting for paying the 8%, for paying employer PAYE right from the start, and then everybody's happy. Also, sometimes people say, well, I'll get the actor to sign an indemnity. The actor who should have been on an employee contract but has to be self-employed may not have any money to give the indemnity. And also, I wouldn't advise anybody to sign an indemnity. I would say, okay, I'll give you an indemnity in respect of the tax I'm liable to pay as a self-employed contractor, but I'm not going to give you an indemnity in respect of the tax and penalties you're liable to pay if revenue come after you 6 years down the line. So while there may be some short-term budgetary and administrative appeal in just retaining everybody as a self-employed contractor, as a producer, you need to be very, very careful that you're not going to get stuck down the line for back payments of tax for the person who should have been an employee. That's the scary bit, and a lot of people don't realize it. Increasingly, it's better to put people on short-term employee contracts, even if they're part-time employee contracts. It's not what anybody wants to hear, but who said lawyers bring you good news? Now, IP in contracts.
Sorry, Andrea, to stop you again. There's a couple of people wondering what it means that they should be an employee. So what kind of constitutes, what kind of roles, I suppose people are wondering, that revenue might look back at and go, that really should have been an employee.
They look in, control is the key element. Control of that person's time and expertise during the period of the contract. If they are working for you, if they must come in at fixed hours, if you tell them what to do, when to do it, and you provide them with the materials to do it with, the chances are that they are an employee. Okay? If you pay them even if they're off sick for a day, the key word is control. Has the employer bought control of the individual's time and expertise? Yeah. If you look on the Revenue Online website, they do have booklets about this that will explain what their criteria are. Within the creative industries, you'd look at the criteria and say, oh, for God's sake, you know, have they no idea how things work? It's all very well if you were going into an insurance company and you were a company servant from 9 to 5 every day, but could go home and forget about the company at the end of the day, or switch off your laptop, the right to disconnect now, and not need to worry about the company. But we all know that when you're involved in a show, you're worrying and thinking and obsessing about it day and night. Your days and nights merge. It's not how things work, but explain that to a 9 to 5 revenue official, and you won't get much sympathy. And they just want to get as much tax in as possible. So the key element is control of somebody's time and expertise. Is that any help?
Yep, I think if another question comes up, I'll bring it up again at the end. That's great. Thank you.
Now, you might remember I said earlier that under an employee contract, the employer owns all the IP in work created by the employee in the course of the work done under the contract. So I'm employing you to be an actor, and if you devise a few lines of the script in the course of doing that, I own what you have devised in the course of that work. If I've got you employee, if it's crew, if it's a lighting manager, if for example a lighting designer or a lighting assistant is involved, the designer will probably be a a self-employed contractor, but somebody who's actually doing a technical job during the performances, they will. If there's any, so that there's no argument about whether they devised those 30 seconds of lighting, you automatically own it because it was in the course of work done by you. It doesn't mean that if that lighting technician is going home and writing a play themselves during their non-work hours, that you own that IP. You own, as the employer, you own the IP in the work they do for you during the contract. Is that okay? Nonetheless, most employee contracts will say, for the avoidance of doubt, you hereby assign to us the totality of all intellectual property rights in any work you do for us. But as a matter of law, you own the copyright in the work your employees do. In self-employed contractors, the self-employed contractors either license the right to use their copyright, e.g. stage design, costume design on agreed terms, or assign the right to use their copyright, which would be a complete buyout. Now, but in an extension of my ironing board example, selling my ironing board. If I sell you my ironing board, I can actually attach some terms and say, look, you know, if you iron any 2 teams camogie shirts, then you're going to give me a residual of another euro, because I'm going to be able to even though you are now own the ironing board, I'm going to get a little bit of money each time you use it for something more. So let's say you've assigned, it's been a buyout of your performer's rights, but every time that show, let's say a recording of that show, is reused on another platform, then you should be paid more money. Arguably, and this is all developing at the moment, but I think there's an argument to be made that the performers should be paid more money, because performers aren't getting the opportunities to live perform at the moment, but their work is being recorded and represented on different platforms. So arguably, there should be another payment made for that additional use of the recording. Similarly, in respect of what a sound designer would do, or let's say a lighting designer would do, or a costume designer, they've designed the costumes, they've designed the lighting sequence, and then that is reused, or it's, forgive me putting it so crudely, but that asset, which is now held by the production company, is sweated by the production company. It's okay, how can I make more money out of what this person has done? hey, a theatre in the West End wants to take it, promote it, unique to their, the National Theatre in the UK wants to take it, unique to their viewers. They're going to sell tickets online, promo it, and make it available for 1 week only in September. So that's the equivalent of another run. But you're not going to be shipping actors and lighting technicians over to London to do it. So they don't have the opportunity to earn more money. So arguably, if you have another platform that you're going to put it on, more money, an additional residual or stroke royalty should be paid to the individual. So what the territory that we're all in at the moment is looking at developing norms for the reuse of recorded work, for the reuse of recorded assets that are sweated by the people who hold who have the recording. I hesitate to use the word exploitation. As lawyers, we use the word exploitation, and we don't mean it in a pejorative sense. We just mean sweating the asset. But that's why I'm using sweating the asset, because exploitation feels like somebody's being unfairly exploited. But we're talking about making this a fair exploitation so that everybody gets some benefit when that asset is reused. So this is a slide about this. There's challenges of digital exploitation. You've only got one live performance only. A live stream of that performance, personally, I would tend to say that's probably the equivalent of people coming to the theatre. So I wouldn't be inclined to charge or pay for a live stream. But any repeat use of that recording online, whether it's streamed so that you can watch it on YouTube, whether it's a private or public channel, whether it's downloaded, whether the theatre or whoever holds the recording. Sorry, I was just checking my phone that I'm still on time and I dropped it underneath the ironing board. So live stream, repeat use of the recording online, streaming versus download onto somebody's device, or whether that individual, let's say it's made available through the Pavilion. That's my local theatre. I used to live in Dunleary, now I live near Dunleary. Very keen supporter of the Pavilion. So let's say a show is created in the Abbey, then made available to the Pavilion, either on the night or the Pavilion can promote it and make it available for a week. The week after, the Abbey makes it available for fees, and the Pavilion charges for it. The asset has been sweated. So what is the actor entitled to expect? That's what we need to discuss these days. What is the actor entitled to expect in terms of that additional use? What is the lighting designer, the stage designer, the costume designer, the composer? What are they, all of those who've made creative input, contributed their copyright works to that layer cake that is the show? What are they entitled to expect? Usually, I would, and I'm borrowing a lot from TV and film models here, because increasingly, those of you who have been living a life that is dedicated to live performances are needing to engage with norms that have been part of the broadcast and film exploitation world for a long time, because due to COVID, obviously, so much of your model of working has gone online, for better or for worse, but that's just the way it is. What in terms of publicity and promotion, I would usually include publicity and promotion as part of the original fee for one live performance on the live stream. But if, for example, I'm aware of publicity and promotion that has extended to poster advertising or sides of buses, if that's going to be done, maybe the actors appearing should get a little bit extra if it's going to be that kind of publicity and promotion. But let's say radio play, online publicity and promote, social media publicity and promotion, and on our own website, that I think should be part of the deal of what's originally paid to a creator or performer for a live performance, a live stream, publicity and promotion. Well, you need to start thinking about, yeah, but what else are you going to do with it? There are absolutely no norms. I've been engaged, and I know Irish Theatre Institute is going to get engaged along with Irish Theatre Forum in discussing and opening up working groups to think how this might be approached. I've been engaged in some early suggestions of how it might be approached. So I'm not presenting this to you as how it works. This is a whole new era that everybody around the world is only finding their feet in. But I would be inclined to say, okay, let's say you've got a live performance, including a live stream on one platform for, let's say, 6 months plus publicity and promotion. Just going to set my last 30 minutes. For 6 months, 1 year, 3 years, whatever it's going to be, that's a flat fee. VOD, which is an acronym for video on demand, either commercial or non-commercial. Let's say video on demand, geo-blocked means available only in Ireland or Ireland and the UK for 6 months, a year, 2 years. Well, let's say I'm going to get X% of my original fee as an additional. And maybe it could be, maybe the producer knows, look, I'm going to be making this available online. So I'm going to pay you a baseline fee for your live performance plus another 50%, 70%, 80%, whatever the norm is going to be developed, to be able to use it as video on demand also, whether the person that we sell it to charges or doesn't charge for it. Let's say that it goes to video on demand anywhere in the world, or video on demand, hey, we've got a special launch with the the National Theatre in London. So we're going to pay you in return for what we're going to get from the National Theatre. We're going to pay you a percentage of Y euro, which was your original fee. So there could be that way, sort of particular residuals, and it could be negotiated all up front, what you're going to get, or it could be say, look, this is what we agreed to and what we'll come back to. If we want to use it again, we're going to use this formula that you agree that we can use it for online anywhere, provided we pay you these residuals if we use it in different media and formats, or in different territories, or on different platforms. I cannot tell you what those fees or what those percentages should be. All I can do is offer you a very rudimentary matrix for how you might think about it. Now, there is an organization, those of you who are also musicians will know about, and producers will know about, the music collection societies, who collect fees for the reuse of recorded music and for the compositions, the songs and pieces of music themselves, when they're played in public or used or included in another show, used in another context. There is an organization called RAAP. It used to call itself Recorded Artists and Performers. It changed a few years ago to Recorded Artists, Actors and Performers. Now, I cannot say that at the moment, RAAP, and I think it'd be very interesting to have discussions with them, for some industry bodies to have discussions with them, now that actors' work is being used more and more online, whether actors could register their performances and a fee could be paid to the various international collection societies for actors that would come back through that collection society network to RAAP, who would pay out fees each year to the actors. It's premature to do that so far. I know that Irish Equity in TV and film works on, or particularly in TV drama, works on the basis of Wi-Fi plus another 100% if you want to use it, or 50% if you want to use it for 5 years on any media, 100% if you want to use it in Y media, in media for unlimited media for 10 years. Don't quote me on those percentages, but I can check them later. But the model is the same, and I think copyright holders and performers in theatre need to start looking at the same model as a way of addressing the new digital platform exploitation media that your work is appearing on. Now, what I'm going to do is I'm going to take, let's see, my last few minutes. I'm going to take 15 minutes looking at, excuse me while I change my timer, 15 minutes, just looking at some exceptions that I've mentioned as I go along to the copyright laws that I've outlined, just so that you understand, both as copyright holders and as people who want to use somebody else's copyright, what those exceptions are, and another couple of small points. And then I'd be happy to stop screen sharing and start addressing questions in the chat room. Is that okay? Okay. Now, I mentioned earlier on that doing anything with copyright that breach that copyright holder's right to copy, make available to the public, and adapt, doing those things without the copyright holder's consent is a breach of copyright, unless an exemption applies. And the exemptions are known under the category of fair dealing. This is also set out in the Copyright Act. It's known as fair use in the US, where its meaning is considerably broader than it is in Ireland and the UK, and across Europe. But fair dealing means the use of copyright material without the consent of the copyright holder in certain circumstances prescribed by law. The objective is to procure that copyright doesn't unduly restrict free speech, education, and creativity. Traditionally, copyright was sort of almost abhorrent. I remember reading an article in a world music magazine called Songlines, and there was a very famous Korean, not an oud, but some beautiful stringed instrument player, and he just couldn't understand for years the idea of copyright, because in his culture, everybody built on the tunes and the stories they'd heard all down through the years. And he couldn't understand that a tune or a piece of music could be owned by anyone, because it passed through the generations, being changed and adapted and built on. And that's what I might call the creative flow down through the generations. Fair dealing is a way of addressing that creative flow. It's trying to find a balance between an individual copyright holder being able to monetize their property interest in their copyright piece of work without unduly restricting that creative flow of ideas across various art forms. The fair dealing exceptions are: you can copy for research or private study. You can copy and make available to the public for criticism or review. So if your play is being reviewed and there's a recording of it available, a little bit of it being played on, for example, Sean Rock's program, though it'll usually be done with your cooperation, that's fine, subject to sufficient acknowledgement of the copyright holder. This usually would be very common in, for example, book reviews. You might quote a bit out of a book review, out of a book, and that's absolutely fine if that's part of your criticism and review. And as long as you say who wrote the book. Reporting current events. So usually if there's a news story and it involves breaching somebody's copyright, for example, let's say there was an Ed Sheeran concert and thousands of people attended for the Ed Sheeran concert. That's going to happen these days, and there might be 30 seconds of the Ed Sheeran concert because it was actually a news item. That's absolutely fine. If you were a journalist, you can't reuse photographs for reporting current events. You can in the US, but you can't in Ireland. Incidental inclusion. Let's say I had a great piece of art on the back, on the wall behind me there, and that's my stepson's Christmas alphabet poster, right? But then it's just incidentally there because I haven't the heart to take it down, and yet a little corner of it appears and all of you are watching it. It's going to be in a recorder. Now, Mark can't come along and say, you breached my copyright in my wonderful Christmas work, because it's just incidentally there. It's not something I've deliberately put there. But if you're designing a set, you deliberately put it there. So to be careful, you need to be careful what visual works you put, photographs, paintings, anything that appears on your set. Quotes, extracts from a published work. This is a dodgy one. Publishers will always get you to clear, a publishing house will always say, I want you to clear all the quotes. But it probably would be okay to include a quote with, as long as there's no prejudice to the copyright holder, so you don't diss them or undermine their commercial chances to exploit their work, and you give sufficient acknowledgement as to who is the owner of that piece of work. And then there are a whole load of rules about school and library use, and there's a whole scheme of licensing work for use by schools, and the copyright holders get paid that way. So the other one that's very interesting, and it came in recently, is fair dealing, a parody. For years, we didn't have a parody law that allowed us to, for instance, parody old advertisements. Or, I mean, I've spoken to some comedians who, actually one comedian who just, one set of comedians who just didn't believe my colleague when she said, actually, we don't have a parody law. And they've been doing parody on television for decades. And they said, you know, you're lying. You don't know the law. We said, actually, we do know the law. You're just getting away with it. But since 2020, we do have, 2019, we do have a parody law, so that fair dealing with the work for the purposes of caricature, parody, or pastiche shall not infringe the copyright in that work, and sufficient acknowledgement isn't required. So you could do a caricature, or parody, or pastiche of a piece of work. So that is actually very, very useful. And we didn't have that until 2019. What's really, really difficult is if you're making some kind of video work and it's got lots of scraps and bits. It's almost like a collage. And under US law, that's called transformative work. And it's not a breach of copyright. But we do not have a transformative work exemption under Irish or English law. So that can be something that's quite difficult. So let's say you want to create a montage of video clips. You will need to actually buy them from a stock house or obtain them from somewhere like, where have we got? Creative Commons. I don't know if you've heard of Creative Commons, but it's really, really useful. It's a voluntary system whereby people make their work available with on a Creative Commons, on creativecommons.org. They make their work available on a basis that no copyright restrictions apply, or only some copyright restrictions apply. For example, you can use this work for whatever you like, but you must credit me as the original creator, and you can adapt it and you can do what you like, but you've got to make, let's say they have different types of license, but you've got to make the adapted work that you create available on Creative Commons on the same basis. Or you can use this work any way you like, but if you're going to use it for commercial purposes or in a commercial show, well, then you must pay me. Very well worth looking at creativecommons.org. So if you want to create a montage piece of video, for example, you do need to either get something that's in the public domain and out of copyright. I was working on something recently where somebody had a show with some Betty Boop images in the back. You know, this tiny little 1930s character, Betty Boop, Boopy Doop. And she, Betty Boop, it's very interesting on the US law, some Betty Boop images have gone out of copyright. Some Betty Boop images are still in copyright, and some Betty Boop images were acquired while still in copyright, retouched up, and then made available. So the touched up versions are in copyright. And it's a real head wrecker to work out which Betty Boop image are you using. But buying them from stock houses is the most straightforward way. Stock companies that have collated. Sometimes people don't understand, oh, but that's public domain. That there aren't copyright restrictions attaching to that piece of pathé footage. And yet that firm is charging me for using it. That firm is charging you for their time and trouble in having collected it, archived it, and made it available to you so that you can just readily download it in a reasonably good quality format, and that you don't have to go searching and doing the copyright research yourself. So that's what they're charging you for. Going back to public domain and publicly available. Public domain is probably the most abused term in the copyright world. We'd say, oh, but that's available in the public domain because I can see those images on Google. Well, it's publicly available, but from a legal point of view, it doesn't mean that it's in the public domain, because public domain has a very specific legal meaning. It means no copyright restrictions apply. It's out of copyright, or the person has made it available for free and you don't have to check the copyright. But there are loads of images and pieces of footage I could get on YouTube, I can get on a Google search, but that doesn't mean just because they're publicly available that I can use it in my show, because copyright restrictions may still apply. And Google says that on Google Images, copyright restrictions may apply. The most famous one perhaps is, I don't use the image anymore because Che Guevara, you know, that screen print that appears on t-shirts and scarves and merchandise of all kinds. Jim Fitzpatrick, who created that, said because I had met him, being Che Guevara, idolized him, and of course wanted to make sure he was never forgotten. I made all the Guevara images copyright free. That's how it spread everywhere so quickly. But 10 years ago, Jim Fitzpatrick said, there's no question the image is one of the biggest in the world. I've never sought royalties for it. I have decided now is the time. This came after there was a row when an advertising company used the Guevara image to sell vodka. And the vodka was, Che Guevara was a teetotaler, and the vodka company was making a lot of money out of it. And the original photographer who took the image, a fellow called Alberto Corda, took the image on the basis of which Jim Fitzpatrick made his screen print. And he had never looked for royalties either. He started looking for royalties because he said Che would never have approved of this. The case was settled, but at that time, Jim Fitzpatrick said, no, I'm going to assert my copyright now as well. And in fairness to him, he gives the royalties to community projects in Cuba. He doesn't keep it for himself, but he asserted his copyright, even though that image was everywhere. It wasn't public domain. It's not public domain anymore because he's asserted his copyright. I won't go into great detail on music copyright, but I will simply say that there are two types of music copyright. There's the copyright in the original composition, which the composer may assign or grant to a publisher who then manages the rights in that piece of music on behalf of the composer. And then the other form of copyright is a sound recording copyright. If there's a record company has actually recorded a song and has paid the performers, has paid the composer for the use of their song, and then sells the sound recording, whether online or in DVDs, increasingly it's online right now, online, there's another form of copyright called the sound recording copyright. If you're using an existing sound recording and incorporating it into your show, you need to pay for the sound recording right, the performance, the public performance of the sound recording. You also need to pay a fee for the public performance of the composer's composition. Those rights are managed by PPI, and you need to get the consent from PPI, Public Performance Ireland, and sometimes they will send you off to the individual themselves, because they may not have the performers. They may say, yeah, we've got the sound recording right, but we don't have the right to include it into a show. You must go and talk to the performer or the composer yourself. But IMRO will manage the composer's rights. They're very easy to get a license from, but you need to think about clearing both the composer's right and the sound recording right. And the theatre will usually pay those, but you need to give music logs to the theatre saying what pieces of music you've used. Now, what else? Yep. IMRO, composers and publishers, PPI, record companies hold sound recording rights, RAAP for performance royalties. If you're using music in your work, check for clearance requirements, especially for commercial sound recordings. The more modern, up-to-date they are, the more expensive they're going to be. And don't forget to budget for music clearances. Creative Commons licenses we've looked at. And the final thing I'm going to look at here is creative collaborations. When you're workshopping a piece of work, Is it a work of joint authorship, or do you need to be clear about the basis of the workshop participation and ownership of the ensuing work? So, for example, a production company says we're going to invite a group of actors in, we're going to workshop this. The original idea comes from our director or our screenwriter. Be very, very clear at the start about how it's going to be used. The models I've seen, as I mentioned earlier, usually comprise, look, this will be owned by the production company, but we're going to give you the first option on performing the roles that you've created if we get funding. Stones in his pockets, just Google it. Mary, who is she? Very well-known Northern Ireland playwright, Mary Jones. And the first scene in Stones in His Pockets was written by was heavily influenced by a draft that the director, who was called, somebody called Brighton, it was another woman. And then when Stones in His Pockets did so well, she claimed she should be getting some of the royalties because so many of her ideas had been included in the opening scenes. And eventually there was a settlement. But Mary Jones got to retain the copyright in the overall play on the basis that she paid a certain amount of money, a once-off fee, to Brighton, the director. Playboy of the Western World, that was one where the Abbey commissioned an adaptation of Playboy of the Western World. Synge is long dead, out of copyright, and they adapted it so that the Playboy was an Afro-American actor, and it was a joint adaptation by a Nigerian based in Ireland, a playwright. I'm trying to remember his first name. His second name is Adigun, and Roddy Doyle. For the second run, only Roddy Doyle was involved, and they changed some of the work. And Adigun, through his company Arambe Productions, sued the Abbey and Roddy Doyle for violating his moral rights. He said, I wrote that originally, and I wrote it in a particular way, and you've messed around with my work in a way that I don't approve of, and you can get away with moral rights from me. So I'm suing you. And it cost the Abbey something like 66,000, was it even more, euro by the time the whole case was settled. Now we are at 24 minutes past 12. Does anybody want to, I'm very happy to answer questions if people have them. And I also have no difficulty, Lee, with you sharing that presentation. If you could just make sure it's in a show format rather than a non-amendable format.
Yes, absolutely.
And I'm happy for people to have those. Oh my God, one thing I will share, maybe you could change for me or I'll share. I adapted them from a set of slides I'd done for ITI in 2018. I want to update that copyright notice to 2021.
Yes, absolutely. I think there's a couple of questions actually around the creative collaborations, and there's some interesting questions about crediting afterwards, actually. If you want to acknowledge the work done by your wonderful creative collaborators in the room, be they actors in the process of creating a play that might have been made through improvisation, is there a particular wording that's kind of been used to credit? So, for instance, an example that was given was in TV, The Thick of It, where the writer Armando Iannucci, but with additional material by the cast. Is there similar wording for theatre productions that can be used to acknowledge the creative input by others?
You could do additional script writing or script developed in association with. Simply say it as it's meant. There's no special legal significance in the wording. The only legal requirement is that there be a credit for the copyright holder, unless you've agreed that they get no credit, right? So if you want to acknowledge them in the simplest, most straightforward wording you can, that fairly acknowledges the work. So, for example, you might have script initially developed in association with, or script developed as part of a workshop collaboration with and list the people who took part in it. Whatever most accurately reflects the process by which the end piece of work appeared. Just saw a comment coming in there from somebody. How will we arrange accountability with actors in a devising process with the cast contributors writing through improvising? Yeah, that's the one. In particular, we want to preserve the rights of the main author, but also to acknowledge, okay, so we've just dealt with that, I hope. That's from, okay, is that okay from the person who asked that question?
They weren't able to make it today, so they passed the question on. Yeah, I think everything that's been covered within it has gone through all the questions that they submitted. There was one from Ronan here about the parody section. So, is there a difference between using a whole or substantial portion of a sound recording and a snippet for comic effect? So, for instance, would the latter fall under use and a credit in the program?
If you are creating a parody of it, if you are just using it for comedic effect, you need to clear it. If it's a well-known song, and forgive me for being crude, but you're doing a piss take of it, right? Then you could probably get away with using it under parody sufficient to original song by or parody of original song by in the credits. However, if you are using it to make it sound funny, to make the piece of work sound funny, you're actually using the music and it's not a parody. When you need to actually parody that piece of work, that song, that piece of film footage, that famous quote or poem or whatever it is, that you're not parodying it if you're simply using it. You've got to be parodying that piece of work specifically. Does that make sense?
Ronan, is that
helpful?
I'll let you put into the chat if you have a further question. There's another one I wanted to. This was about in contracts, making contracts and distinguishing between an employee contract and then also the self-employed. So for the end, so if you have employed someone as a collaborator and they work on the project as a performer, made in collaboration with the artistic director or producer, some of this work will be done in their own time and some of it will be scheduled rehearsals. Do they then have to be contracted as an employee or can they just be a contractor?
I'm going to ask you to read that out to me again so I get all the bit. I see where they're getting, but just read it one more time.
Yeah, no worries. I, of course, moved myself on from it, so just give me a second to find it.
I've just got to get the dramatis personae all organised in that one. I'll make a note.
Yes, so if you've employed someone as a collaborator, so they work on the project as a performer, made in collaboration with the artistic director or producer, some of this work will be done in their own time and some in scheduled rehearsals. Do they have to be an employee or can they be a contractor?
Okay, as a collaborator, they can be a self-employed contractor, but they should be given an employee contract for the run of the show when they're in their role as a performer.
Okay, that's great. Thank you.
Budgeted to employ an actor, so you employ the actor for that. But if they are collaborating in their own time as a creative collaborator or an editor or something like that, editing in some way, working on the script in their own time, they could be a self-employed contractor. So they may be self-employed up to the point that you're actually producing the show, and then you put them on an employee contract to actually perform the role. But make sure that you specify that the employee contract applies to their role as an actor, their performance as an actor only, no reference to doing anything else.
Yeah. Just before anybody leaves, I just wanted to say thank you so much for joining us. This was our third information session in the series on Accelerate. You can also see the two previous sessions, The Good Bookkeeping with actor, writer and chartered accountant Peter Daly, and Thinking of Setting Up a Company with Claire O'Neill, General Manager of This Is Pop Baby, on our YouTube channel. And this will become available as well on the YouTube channel. Thank you, Andrea, so much for today. And thank you as well to Rethink Ireland for the funding from Innovate Together. And also ITI is funded by the Arts Council, so thanks as well to them. Thank you, everybody.
Thank you very much. Goodbye, everybody.